Hello. Hello, panel. Welcome to our panel. Do we have 14 participants. We have 14 participants. I guess we don't see them, but I guess you are there. So we will begin the panel. And the panel you are attending is and we welcome you to the section on criminal justice's rescuing law panel on fetal harms, moms, migrants, and Me Too. And the panel is going to explore the shifting intersection between criminal law and the rights and duties of rescue. Our august panelists will share their original research on laws governing Samaritans, Bad Samaritans, Good Samaritans, immigrant harboring, fetal harm, and the failure to protect in order to surface both the underlying shared theoretical commitments and the critical distinctions across these diverse areas. And I tried to sound like I wasn't completely reading that. We've got four wonderful panelists today. We've got Megan Boone of the Wake Forest University, professor of law. Megan has published in the California Law Review, George Washington Law Review, Georgetown Law Review, among others, and was the co-winner of the AALS Association of Law School Scholarly Panels, the competition with her article, Reproductive Due Process. What we'll do is each of the panelists I'll introduce each right before their presentation, and they will give you a brief presentation. The panelists will discuss their work and prominent questions that arise, and then the audience will be asked to participate, join in with your comments and questions. That should take us, approximately an hour and 12 minutes and almost 30 seconds. So let's get started. Megan, you want to talk first about your topic?
Sounds great. Thank you so much, Jay, for moderating and introducing me. I'm so excited to be here, although I know, as we all do, I wish we were together in San Francisco. While I never intended to focus my scholarship on criminal law, my research interests have always centered on the rights of parenting and pregnant people. And unfortunately, the criminal justice system is increasingly playing a role in pregnant people's lives as the state takes an ever more interventionist approach in individuals' reproductive lives. The paper that I'm presenting today, co-authored with Ben McMichael, is called State-Created Fetal Harm, and it lives at this intersection of pregnancy and criminal justice. Specifically, it examines the efficacy and the constitutionality of fetal endangerment laws, a blanket term that we use that's meant to encompass laws that criminalize behavior in pregnancy that would not otherwise be criminal. So a brief note on this choice of terminology. We use the term fetal endangerment as opposed to fetal harm because many of these laws criminalize behavior that just causes risk of harm to fetal life without the necessity of actually showing that harm has occurred. So for instance, women have been criminally prosecuted for the ingestion of drugs while pregnant, even if they go on to have a perfectly healthy baby. This fits into our conversation today, as I think it places this affirmative duty on pregnant people backed by the threat of criminal prosecution to protect fetal life from even the possibility of harm. So not only a duty to rescue, but a duty to prevent against even the need for rescue. So first, I'll briefly talk about the data. So we use the National Vital Statistics System, which is maintained by the CDC, and focused on 3 separate data sets covering the period from between 2005 and 2017. Births, fetal deaths after 20 weeks of pregnancy, and infant deaths in the first 28 days of life. While publicly available versions of these data sets do exist, we utilize the restricted versions because they contain information on the location of individuals, which was necessary for us to isolate the impact of state laws, which is what we were seeking to do. So our analysis focused primarily on Tennessee's short-lived fetal endangerment law, which made it a crime to ingest illegal narcotic drugs while pregnant. The law provided a real natural experiment because as the result of a sunset provision, it was only in operation for a little over 2 years. It had both a clear beginning and end date. So our analysis started with just an examination of various health outcomes in Tennessee before, during, and after the law's passage and its sunset. We then estimated a series of difference in difference regression models and used an innovative synthetic control technique to isolate the effect of Tennessee's law from other factors. The result of both of these analyses was very clear. The fetal endangerment law resulted in a statistically significant increase in fetal and infant death. So in other words, these laws, which are purportedly designed to protect fetal and infant life, are demonstrably perverse. They create more of the outcome that they purportedly seek to avoid. The data also suggested a pretty clear mechanism for these increased deaths. Pregnant people were considerably less likely to seek out prenatal care during the operation of the Tennessee law, and to a lesser extent for the period following the law's sunset. I want to say I'm happy to answer general questions in our Q&A time about the data and what it shows, but would enthusiastically point any more technical questions about the analysis in this part of the paper to my brilliant co-author, Ben McMichael, who is unquestionably the empirically minded portion of our duo. Many scholars have made arguments about why these fetal endangerment laws are just terrible, including arguments about why they are unlikely to work, about how they undermine fundamental rights and reproductive autonomy, and importantly, about how they are enforced almost entirely against poor women and women of color, despite the fact that wealthy white women engage in similar behaviors during pregnancy, with some evidence actually suggesting that those women use drugs during pregnancy in a larger proportion than their non-wealthy, non-white counterparts. Our argument built on the consistency of these arguments against fetal endangerment laws and folded in this new empirical evidence to make what I think is a unique constitutional argument. So if fetal endangerment laws don't work, indeed, we've shown that they do the opposite of the legislative intent, then we argue they ought to be vulnerable to attack on the basis that they are patently irrational. Under the Equal Protection Clause, laws that don't implicate a fundamental right or suspect class must only survive rational basis review. There must be a legitimate government interest, and the means adopted to further that interest must not be irrational or arbitrary. As the protection of fetal and infant life has long been accepted as a legitimate government interest, the sort of only remaining question becomes whether classifying pregnant women as susceptible to criminal prosecution for behavior when non-pregnant individuals would escape such prosecution is a rational method of promoting that state interest in fetal and infant life. Our analysis, which builds on the mountain of scholarship in this area, clearly shows that it is not rational. Indeed, by pursuing criminal prosecution of pregnant people, the law promotes fetal and infant death. So using this framework, we argue that while a state is not required to produce evidence to support its legislative actions, it is not free to ignore empirically observable adverse outcomes of its own actions once that evidence exists. It's not rational to continue to engage in acts that have the opposite outcome of your stated intent. So whatever prediction about outcomes that formed the supposedly rational basis for the original law simply no longer stands. In my current project, I delve deeper into this idea of demonstrable perversity as irrational and unconstitutional, and how it might apply to other areas of law, including in the reproductive and the criminal justice space. This actually includes an analysis of mandatory arrest laws for domestic violence as potentially perverse, and I think reflects some of the larger themes of our conversation today. As scientific and empirical methodology continue to improve, and information systems evolve to make the dissemination of information almost instantaneous, I believe that that the rationality inherent in rational basis review must evolve alongside it and deal with these demonstrably perverse laws. I went as quick as I could. I'll stop there.
Okay, it's better if I unmute myself. Is that right? Zachary Kaufman is our next speaker. Zachary's a professor of law and political science at the University of Houston Law Center. Zachary's got a lengthy list of publications, which will probably take the rest of the panel time to discuss. He's on his fourth book. He got his JD from Yale and his PhD in international relations from Oxford. And Zachary, if you will.
Thank you, Jay. I greatly admire and really appreciate the opportunity to be here with Megan, Shalini, Jay, and Sarah. While most of us here have been writing on the subject of rescue for just a few years, Jay's seminal work dates back decades. His 1985 article, The Duty to Rescue, A Re-Examination and Proposal, was one of the first pieces of scholarship I read on the topic and remains an inspiration and touchstone for all of us. I've sought to contribute to the literature on bystanders and upstanders in several ways. These interventions are embodied in a series of articles, essays, and op-eds I've been writing on the subject that will culminate in my next book, which is now under contract with Cambridge University Press. My work centers on so-called Bad Samaritan laws, statutes that impose a legal duty to assist others in peril through intervening directly, also known as the duty to rescue, or notifying authorities, also known as the duty to report. First, I've concentrated on third parties to a particular situation, sexual crimes. My first major work on this topic, protectors of predators or prey, bystanders and upstanders amid sexual crimes, was inspired by the Me Too movement. While many commentators about those horrifying revelations were understandably focusing on perpetrators and survivors, my intervention was to analyze the role third parties have played in such offenses and to consider whether and how they should be held accountable for their passivity or for enabling. Second, having recognized that not all third parties are equal, I concluded that grouping them together under the general categories of bystanders and upstanders obscures distinct roles, duties, and culpability for violating those duties. I've thus presented original typologies of bystanders and upstanders that introduce greater nuance into these classifications and my proposed range of legal and moral responsibilities. Third, I've endeavored to correct conventional wisdom on the supposed rarity of Bad Samaritan laws by demonstrating that they are far more prevalent, particularly in the United States, than scholars had previously recognized. Such laws exist to varying degrees in 29 US states, Puerto Rico, and US federal law, as well as in dozens of foreign countries and multiple subfields of international law. Fourth, I've proposed ways to draft or amend Bad Samaritan laws to make them more effective and current and to address some of their counter-arguments. Fifth, I've considered how carrots, as well as the sticks of Bad Samaritan laws, could be used to incentivize upstanderism. Finally, my second major work, Digital Age Samaritans, is forthcoming this spring. This article builds on protectors of predators or prey, making three primary contributions. First, because the enactment of most Bad Samaritan laws preceded the digital age, the article considers the opportunities and challenges for addressing bystanderism today. Modern technology enables people to view, document, and share evidence of crimes contemporaneously or shortly after. Electronic transmission and receipt of this material, including through social media and mobile devices, raises legal, moral, and practical questions about spectators' responsibilities. Second, recognizing that much of the deep analysis of bystander liability relies on the same three case studies, I've developed an original detailed case study in this article involving the over 700 online witnesses to a live-streamed rape in the United States. Finally, recognizing that Bad Samaritan laws are ambiguous, anemic, or antiquated, The article proposes a model duty to report statute for the digital age that explicitly includes features such as applicability to virtual presence and reasoned exemptions for noncompliance. I've been honored that policymakers have begun using my work. For example, a new bill introduced in September by 3 congresspeople, the State Harassment and Assault Prevention and Eradication SHAPE Act, incorporates my proposed language on bystander intervention. The legislation aims to combat sexual abuse at the U.S. Department of State. Thank you, and I look forward to our discussion.
Thank you, Zach. Thank you very much. Our third speaker is Shalini Ray. I'm going to mess it up, but good. Let me take a second. Shalini Ray. How's that?
It's Shalini. Thanks.
Shalini.
Yeah.
Oh, okay, Shalini.
Right the first time.
But I'm afraid I've used up all of Shalini's time, so we'll move. Well, actually not. Shalini is another distinguished member. She's got her BA from Stanford, a JD from Harvard, and she's published up a storm, including Berkeley, Boston College, Ohio State, and that's just the start. So Shalini, Professor Ray, please proceed.
Thank you so much, Jay. It's great to be here with everyone talking about our work on laws of rescue. So for some years now, I've been pretty interested in how the law regulates acts of rescue in different settings. Typically, when we talk about the law of rescue, we talk about whether and under what circumstances there might be a duty to rescue and what the scope of that duty might be. But I'm interested in a different aspect of the law of rescue, situations in which the criminal law prohibits rescue, where it's actually illegal to assist or rescue another person. I'm interested, in response to that, I'm interested in whether and under what circumstances there might be a right to rescue under the law. So a prime example of this phenomenon of prohibited rescue is the criminalization of humanitarian aid to unauthorized migrants. So migrants make dangerous journeys to haven states, and some encounter serious peril. Migrants walking from Mexico into the United States die of dehydration in the Arizona desert, hundreds of them a year. Migrants trying to reach the shores of the EU to apply for asylum frequently drown in the Mediterranean. Civil society actors, usually nonprofit organizations, have organized in response, setting out jugs of water in the Arizona desert, sending out rescue crews in the Mediterranean. And they have regularly been prosecuted for migrant smuggling or migrant harboring. In the US, we have a federal criminal statute that proscribes various acts with respect to unauthorized migrants. So namely smuggling, transporting, harboring, and inducing to remain. And harboring has been interpreted very broadly in some circuits to mean substantial facilitation. So no requirement that there be an effort to evade law enforcement or anything like that. That in turn, that broad definition of harboring has been what the government has primarily used to target humanitarian actors. And what we've seen in response to these prosecutions is new forms of resistance to criminalization, notably the pursuit of exemptions to criminal liability based on religious belief under the Religious Freedom Restoration Act, or RFRA. In a high-profile case last year involving a volunteer with a Tucson NGO, No More Deaths, the defendant, Scott Warren, succeeded in winning an exemption under RFRA with respect to his misdemeanor charges, but he was not successful with respect to his federal harboring charges, although he was ultimately acquitted of those charges by a jury. So these sort of religious belief-based exemptions are an area of emerging area of relief for those facing criminal liability, and so that's promising for them. But I'm not sure that religious belief or even political expression is the right foundation for conceptually or doctrinally for a potential right to rescue. So for example, in France, the French Constitutional Court ruled that humanitarian smuggling of migrants could not be criminalized because it was an act of solidarity. And acts of solidarity could not be criminalized because the French Constitution guarantees not only liberty and equality, but also fraternity. And I think this idea of fraternity or solidarity is very interesting and important, although perhaps somewhat foreign to US law. So a liberal focus on conscience or political ideology, political beliefs, doesn't really capture the idea of solidarity. But that doesn't mean we have nothing to work with. The closest I think we come to potential legal protection for acts of solidarity in US law would be the First Amendment's implied freedom of association. The history of the labor movement and movements for racial justice really showcase the importance of the freedom of association, although it has also been used to exclude subordinated groups, so it doesn't always lead to inclusion. I'm interested ultimately in conceptualizing a right to rescue in US law, looking comparatively to other jurisdictions that criminalize migrant rescue and to develop and evaluate doctrinal pathways to resist criminalization. Thank you.
Thank you. And Sarah Swan is our final panelist. Sarah is a professor at Florida State University. And she's gone to a variety of different Columbias. She got her JD from British Columbia and her LLM and JSD from just plain old Columbia. And she too has published a great deal in widely in wonderful journals, Duke, Vanderbilt, UCLA, Wisconsin, what have you. So Sarah, your turn.
Great, thanks, Jay. So like Megan, my current project is about prescribed maternal duties, but I'm looking at duty as it occurs further along in the family cycle, criminal liability for moms who fail to protect their children from abuse. So in my 5 minutes, I'm going to give some quick background to the area, and then I'm going to sort of tee up a couple of issues in this area that I see as having broader implications for other applications of rescue law. So by way of background, in the 1960s, following the Kitty Genovese murder in Queens, the movement towards imposing duties to rescue gathered momentum and steam, and it spread out in multiple directions. So one place it went was towards duty to report and failure to protect laws for child abuse, a social problem which was just then achieving a critical mass in the public consciousness through publications like The Battered Child Syndrome, an article published in 1962 that really exposed the prevalence and reality of child abuse. As this dual push towards increasing duties to rescue and preventing child abuse went forward, we saw statutes proliferate across the nation that explicitly criminalized the failure to protect, and they made it a criminal offense for a parent to permit or allow their child to be abused by another person. The associated punishments with this are often a maximum of a few years imprisonment, but we do see some very severe penalties, for example, in Oklahoma. In addition to the creation and use of these specific statutes, we also saw more general criminal liability statutes used as well. So that's the legal framework. What's important about these cases? First of all, they're deeply gendered. They don't say they just apply to moms, but in reality, they do. Secondly, or actually, I'll just explain that gender skew a little more. So as many scholars have detailed, ideas of motherhood are obviously really important here. It's seen as a mother's ultimate duty to protect or rescue her child. There's also just more broadly a tendency to blame women for male violence. A second important background point, we know that in about half of the cases where the husband or boyfriend is violently abusing children, he's also violently abusing his wife or girlfriend. But the fact of that adult violence doesn't help moms facing failure to protect charges as much as we might think it would or should. Building on that backdrop, here's a couple of themes from this specific area that connect to recurring issues in rescue more generally. First is this thin line between, but a really important line, between individual liability for failure to protect and complicity liability. So within this Venn diagram of accomplice liability and failure to protect liability, there's an overlap where something could be characterized as either. But it's important to keep the doctrinal parameters clear about what must be proven in these different doctrinal buckets. So we see courts in some cases saying there's no difference between failure to protect and aiding and abetting, that if you have a failure to act and a duty and you're present, that is aiding and abetting, full stop, and that's not correct. The second big issue relates to equating the failure to protect with actual aiding and abetting. So the failure to protect is in multiple ways framed and equated with actual violence. And we see this in a pattern of sentencing mom to a longer imprisonment term for her actions of failing to protect than dad gets for being the primary physical abuser. And we also see this in child removal proceedings, where child protection departments sometimes explicitly say that moms engaged in domestic violence by being victims of that violence. Finally, we see moms get scapegoated and sort of become the focal point for much broader institutional and state failures to rescue that are occurring.
Thank you. Do any of the panelists want to ask other panelists anything with respect to their presentations? Well, I'll get started. Sarah, let me ask you, when this burden is placed on usually the mother, and she's asked to intervene, this seems to paint her into a corner with an abusive husband where she'll face serious abuse herself for doing so, where sort of as with the battered woman syndrome, she often can't leave. She doesn't have the economic resources. The husband will have control of them to leave. And so she's between a rock and a hard place. Would that be a legitimate observation?
Yeah, that's absolutely what's happening. And so you do see a few states offering up an affirmative statutory defense. So if mom can show that that was why she wasn't, or that was why she was failing to protect, then she can make out that defense. But that's a small minority of states that offer it. And what we do see is just in application, the impulse to blame mom for what has happened, regardless of what the cost to her would have been, and regardless of the fact that there were multiple failure points in almost every case. So a lot of the times you'll actually see other bystanders intervening. So you'll see things like teachers calling child protection. You'll see neighbors calling police and child protection. And you'll see child protection just completely drop the ball. And so and other times you'll see moms who did try to leave and were sort of, physically dragged back under threat of killing the child or other reasons. And they don't actually matter much in the end results to courts. They just doesn't garner the kind of sympathy that you or I might think it would garner.
Let me just follow that up, and then I'll recede. The children here are the initial victims, and it would seem that you further victimize them when you remove the mother from the household. It's then they have no parents. Is that a problem too?
That is a problem, and actually it's an even sort of more complicated problem. So there's just been a terrific series, I think it was USA Today, published a series of articles about this problem in Florida. And in one of them, a woman who's charged with failure to protect for her husband's violence, the kids are taken away from her, but 2 months later they're given to him because the courts say he's changed. And so she's left without her kids for failure to protect. And it's not funny, but it's just so absurd. And the primary wrongdoer gets the children.
Yeah.
I would just pipe in to say that the exact same story happens in the fetal endangerment context, where we have women being prosecuted for prenatal drug use. As a result, their children are taken away from them, often immediately after birth, which deprives the children of some of the most effective interventions for things like neonatal abstinence syndrome, which is, that great skin-to-skin contact. And we know that these kids have less, the outcomes are less positive as a result of them being removed from their mother, even in the presence of prenatal drug use. So it just exacerbates the existing problem.
Megan, I wonder if there's another problem with that as well. I mean, I would imagine that not that many mothers who are followed by private physicians who are insured and go to private OBGYNs. I'm just going to guess that fewer of them are reported to the authorities because they don't want to let this get around and it harm their practice. I would imagine mostly it happens to uninsured women at public hospitals, perhaps more poor and disparate impact on poor and minority. Could there be a disparate impact here with this law?
Oh, without a doubt. The fetal endangerment laws are, the brunt of fetal endangerment laws are absolutely borne by poor women and women of color. Historically, during the sort of crack epidemic, it was almost entirely Black women because the racial makeup of the opioid epidemic is different. It's no longer just Black women, but it's also poor white women. But as I mentioned briefly, there's actually a lot of evidence to suggest that wealthy women and white women use drugs in higher proportions during pregnancy. And yet there are almost no incidents of them being prosecuted under these laws. They're absolutely have a very disparate impact for a couple of reasons. The one that you suggest, which is they're more likely to rely on public hospitals. Their sort of interface with the medical system is likely to open them up to the sort of prying eyes of the criminal justice system, but also just because of institutional racism. So healthcare providers are sort of more likely to assume drug use when they're presented with a woman of color or a woman of lower socioeconomic status, even though the data doesn't bear that out.
And it would seem economic interest too of the private physicians. Yeah.
If I could add a thought, Jay, if that's okay.
Please.
I thought I would just mention though that interestingly there are some cases where mothers have been able to defend against charges under supposed violations of affirmative duty. So here I'm thinking about a really fascinating case in Ohio in 1985, State versus Wardlow, where a mother knows that her live-in boyfriend is molesting her teenage daughter. And so she's convicted at trial of violating the state's duty to report what many view as sort of a subset of rescue. But on appeal, she successfully argued that if she had reported, because she knew that the abuse was occurring, she would have self-incriminated on child endangerment. And so, there are various constitutional challenges we could offer about Bad Samaritan laws, against Bad Samaritan laws, and the issue of self-incrimination is one of them and has been successfully used.
Great. Next panelist question of what our panel has discussed.
So one thing that what occurred to me during our discussions is that a couple of people brought up the idea of changes in technology as really fundamentally altering the law of rescue in your particular area. I think that's true for my own piece. And I would just be interested to hear if people wanted to talk about how rescue and the duty to rescue and the duty to protect have changed just in light of the technological advances that have really happened very recently.
Well, I can share a thought on that, since that's the subject of my my forthcoming piece. Obviously there are lots of different kinds of technological developments that are at play here, or could be. The ones that I've focused on are mobile devices, the advent of mobile devices, and social media. So I argue that these have had an immense impact on our conception of rescue and reporting, and culpability for violating any such affirmative duties. And there are a few reasons why. So, first of all, these devices and software, can be used to document crimes and other crises, non-criminal crises like drowning, to be shared and viewed either later or even while the events occur. So what's new here, of course, is that people can view crimes from a far remove, and that's new. Also, these devices and social media can reduce both the burden on and risk to witnesses in reporting emergencies. So if we go back to what Sarah mentioned about the possibility that you might imperil yourself if you were to intervene, typically we think of that in terms of being physically present. If you're virtually present from a far remove, one would think that you have less of a physical vulnerability to the perpetrator or to the crisis. And then finally, mobile devices and social media, can be used to establish the presence and behavior of witnesses, including whether witnesses act passively or actively encourage or enable perpetrators. In the case study that I've developed for this new article, Digital Age Samaritans, where there were over 700 witnesses to the live stream rape, some of them were prodding the rapist to continue, were giving thumbs up and hearts. We're asking the live streamer to remove the blanket so that they could see better. Because this was recorded, we have evidence of what they were doing, that they were actually, proactively participating in the rape and egging on the perpetrator. So in short, technological advances, at least the ones that I've looked at, social media, mobile devices, are increasing awareness of emergencies. They're decreasing, I think, justifications for not reporting them, and they're strengthening evidence of witnesses and their conduct.
Thank you. I just wanted to add something quick. So it's not something that I really have focused on in my scholarship, but new technologies, mobile technologies, have definitely had an impact on the way cases, I think, are investigated and the evidence, used in prosecution. So even in the case that I was talking about, the high-profile case in which the defendant was ultimately acquitted for giving food and shelter to a couple of unauthorized migrants for a couple of days, the government was aware, I think, of the existence, of the property where this was happening, due to surveillance, but also, I think through various technological surveillance, they had a lot of information about who was where, when. And I think talking sort of more broadly, when you talk about what's happening in other parts of the world, when migrants are sailing across the Mediterranean, a few years ago, I've read stories where, they're able to contact a priest in Italy who kind of can tell them, where they can land and, safely. And I think governments are skeptical that, the more coordination you have, the more it looks like kind of smuggling rather than a kind of, I've encountered you in the wild and I'm assisting you, which is sort of how we think of rescue most of the time. And so I think some really challenging questions arise due to new technologies.
I'll just chime in. So interestingly, it's not just that duty to rescue is impacted by technology, it's also that duty to rescue impacts technology. So the relationship actually works both ways. So if we look at the Kitty Genovese murder, that was a large prompt for actually getting a nationwide 911 system going. So we saw that have a huge impact on what technology actually looks like and what gets implemented. The other thought I had is, technology can also, I think, sometimes complicate how to report. So for instance, there was just a really awful story about someone who was murdered in a Russian live feed. And it took a long time and a lot of people were watching. And I was sort of thinking through how you would bystand in that situation. Like if all of a sudden, I'm rummaging through the internet and I find this awful live feed of something happening in Russia, I don't even know that I would know how to alert someone if I wanted to. So I think we might need to think whether there's other technological things we need to happen to enable bystandering in those kind of cross-jurisdiction moments.
If I could just respond maybe directly to that issue, because it's something also I've been thinking a bit about too. I divide in this typology that I mentioned I've been developing. I divide familiar receivers, what I call familiar receivers, from unfamiliar receivers, and those are people who are watching a crime occur over, for example, social media, who know relevant information about what's happening, such as where it might be happening or who the people involved are, versus unfamiliar receivers. And in a hierarchy that I develop about culpability, I would hold familiar receivers more culpable than unfamiliar receivers. Sarah is absolutely right that if you don't have any contextual knowledge of what's happening, where it is, when it is, and who anybody involved is, it is unclear to whom you would report. But sometimes people do know. In the case study that I've developed, the Gates-Lonita case in Digital Age Samaritans, there were several people who were watching the live stream rape who knew exactly who the people were and where it was happening. And so those people could report to the locals in Columbus, Ohio, the local police department, and give helpful information about the identities of the people involved. Thank you.
Perhaps you could consider making the social media platforms having a duty to rescue when they identify something, rather than simply if and when somebody observes it. That may be a quicker intervention.
That's absolutely right. And I mean, they certainly have data that others don't have access to. They often know, information about the location of the account from which, for example, a live stream is being broadcast. But through Section 230, the Communications Decency Act, and other protections for social media companies, duties to intervene, whether rescue or report, have largely been viewed as inapplicable to corporations.
And as you said, they may have information that they have to suppress by virtue of their policy and not place on social media. So they're the only holders of it.
That's right.
Well, Shalini, question for you, if nobody else has one at the moment. What you're talking about is what, 8 USC 1324?
Yeah.
And they talk of so you said you talked about migrants. I think they use the word alien in there, don't they? And define alien as a non-U.S. citizen without permission of the government to be here. Mm-hmm. And that's extensive. That's not just people wandering across the Mexican border, wandering in the desert. There's millions of those people. Mm-hmm. Doesn't 1324 criminalize where harboring is defined to be substantial facilitation, I guess, of one's presence. Mm-hmm. Doesn't almost any exchange that benefits them, that allows them to subsist here, mm-hmm. Facilitate their presence and thus violate the law.
So, that's a really, really important question, because that could implicate kind of lots of citizens who interact with people who don't have permission to be here, undocumented or unauthorized migrants. So in general, there have been anecdotal, I think, cases. There was a story in the New York Times recently about a woman who stopped her car to assist two teenagers who were migrants who needed help, and literally, stopping her car and letting them come in and then starting to drive, she got pulled over, and it was transporting unauthorized migrants, was the charge. And so, I don't know that those cases succeed ultimately, but there's certainly a lot of huge chilling force, caused by that statute. And, I think in the circuits that have this really broad interpretation of harboring, I think substantial facilitation, it can't be, probably can't be de minimis, but it also is really broad. And I think the reason why the No More Deaths activist was acquitted was because, the jury had to also find that he intended to violate the law, and that they didn't find. So on that element, I think, that offers some protection, I think, to people who are not sort of out there trying to harbor unauthorized migrants, but are just sort of engaging in everyday transactions. Judge Posner has a really good decision, I think it's Costello, when he was on the Seventh Circuit, and he sort of talks in that case, I don't remember the exact posture, but at the end of the day, he was basically saying that a woman who has an undocumented boyfriend, is not going to be is not supposed to be swept up by this statute by living with someone who's undocumented. That's not going to render someone vulnerable to prosecution. But I think there's a lot of uncertainty, and it is a very broad statute.
Thank you. Thank you. Okay, 3 seconds of silence, and I'll chime in. It's automatic. Zach presented us with a question, a wonderful question. What recent developments have or should have changed our thinking on bystanders, upstanders, and enablers? Very broad question that encompasses all of our interests.
Well, one of those answers I would offer we've already sort of discussed, and that would be technological developments. For me in my work on sexual crimes, the other major development I think has been the Me Too movement. So, third parties have sometimes, maybe often, disregarded or even enabled sexual crimes. As just one example, at least 16 individuals admitted witnessing or knowing of Harvey Weinstein's sexual misconduct, but remained silent. And his behavior was notorious within both Miramax and the Weinstein Company. So given this and many other revelations from the Me Too movement of third-party passivity, I really think we're compelled to return to the age-old question of what, if any, duties do we owe our fellow human beings? Criminalizing sexual abuse is clearly inadequate, and calling on third parties, including men and boys, to help combat this epidemic voluntarily has likewise proven insufficient. So I think we really do need to consider new strategies to prevent and punish such heinous offenses. In addition to the example that I just offered about Weinstein, in the Nassar case, dozens of people knew over many years from the FBI, Michigan State University, USA Olympics, about the allegations and accusations, and did nothing. And so this, I think, comes back to sort of the question about, is it appropriate to use the law, including criminal law, to prod individuals to intervene in such scenarios? And given what's at stake, one could argue that it might make sense, especially because if there had been intervention earlier in any of these, widespread cases, perhaps there would have been fewer victims.
Yeah,
I would chime in, and I wouldn't say that this is a development per se, because I don't think facts on the ground have changed here. But I would say that the sort of development of a more broad-based cultural understanding of who is expected to rescue, who deserves rescue, that these sorts of issues should cause us to have a much more critical perspective. So I agree with Zach entirely that we need to have criminal culpability attached where it should. But I also think we can't look at each individual act, right, and decide if there should be criminal culpability, because those individual determinations are so affected by our deep biases about who's responsible and who deserves rescue, and we should take a critical sort of wide angle view of these laws in thinking through who has these additional legal duties, because I think, as both Sarah and my own work really are a testament to, often if there are additional duties to rescue or help or et cetera, that those duties fall disproportionately on certain populations and certainly along gender lines.
I've also heard, it's a good point, thank you. I've also heard the criticism that, if we create more general forms of duty to rescue, that will crowd out acts of heroism or altruism, which I personally don't see that as a good argument, since I don't think a general duty would require heroic behavior that where one is at great risk, only if one is at insignificant risk to themselves. Well, we've got 24 minutes left, which just happens to be we've allocated to audience comments, audience questions, interaction. So anybody out there, please volunteer. I assume you can unmute yourself or send a question through the chat mechanism.
I'm not sure that participants can send a question through our chat mechanism.
Okay. I don't see people's pictures. So, but I see all the other participants muted. They can unmute themselves and play with us. I'm sorry. Does that allow for audience questions? Okay. Megan, you're actually everybody now is muted. Megan is.
Yeah, I think participants are not able to unmute themselves. So I don't know if there's a global setting.
Am I muted now?
No.
Okay,
No.
Good. I am now on both platforms, so I can see our audience questions.
Okay.
Ooh, okay.
Oh. Yeah, I don't. Yeah.
Yep. So I'm just scrolling back to see where our questions start. Okay. Sorry, going back in the chat.
How do you do that?
Okay, I'm not sure if this is the first question, but it seems like the first question I'm getting to here. Okay. I have a question for Shalini. Have you reviewed U.S. Supreme Court cases on religious expression and/or freedom of association for their underlying reasoning? I wonder if there might be something in that reasoning that could help you build an argument for a right to express solidarity.
Yeah, thank you. I'm just sort of at the start of this new project, and am sort of doing a comparative look across different jurisdictions on how the freedom of association is regarded in different countries. And definitely I'll be doing a deep dive into US jurisprudence. And I will look there.
Great. So the next question is a question for the whole panel. Do you anticipate that in the new administration, there will be movement in this area of law on a federal level? If so, what might that look like? off the top of my head, I think that Shalini's work on humanitarian aid to unauthorized migrants would be the area of law most likely to change at the federal level. But I'm interested in hearing what everyone has to say on that as it relates to their specific areas of scholarship. Since I asked the question, I'll just chime in very quickly with my own answer, which is I actually think that there is a growing consensus that fetal endangerment laws are not just ineffective, but that they are harmful. And considering the increased focus on maternal mortality issues, I think that this is an area that in the new administration, I have possibly naive but optimistic hope that there might be some political will towards eradicating these types of laws.
Yeah, I'll just say something quickly. So I think it's true that the new administration, I think, can make a big difference when it comes to prosecutions under 8 USC 1324. I think for a long time, those prosecutions were much less common. And in the last few years, were really ramped up by US attorneys' offices in those border states. So I think that is likely to change going forward.
The president can do a lot, but I think I could give you a more concrete answer after 7 o'clock tonight.
If I could offer a thought too, interestingly, at least in the space that I research on sexual crimes, we're actually already seeing an expansion of federal law on this topic. So the Protecting Young Victims from Sexual Abuse and Safe Sport Authorization Act of 2017, which was enacted in 2018, it was inspired by the Nassar case, and it requires reporting suspected child abuse, including sexual abuse, in a particular context, and that's minor or amateur athletes at a facility under the jurisdiction of a national governing body. So it's extremely narrow and sort of like really tailored towards the Nassar context. But we are seeing some federal law developing, and in addition, the bill that I mentioned that I contributed to, the State Harassment and Assault Prevention and Eradication SHAPE Act, which aims at combating sexual abuse at the U.S. Department of State. That also could very well become law. It was just introduced, recently, and so we'll see. So I think that there really has been a lot of attention on sexual crimes and sexual misconduct, and we're starting to see initiatives even at the federal level to try to proactively prod affirmative duties in this context.
Great. More questions?
I've got a pair of questions from the chat if we're ready to move on. So the question is, the increased duty to report or intervene that Zachary discusses may be risky in translating into the surveillance and punishment of low income and people of color that Sarah and Megan discuss. What is the right balance here? And then there's an additional question right after that says, it's follow up on Cynthia's question, does it make sense to distinguish between a duty to rescue and a duty to report? For those of us who are abolitionists, there may be a problem with the latter that doesn't exist with the former. I mean, certainly I feel like I've already completely agree with the premise of the question, which is there's a real potential downside to increased intervention and involvement in already vulnerable populations as a result of these types of laws. So I'll let someone else.
I would like to see there be more of a state duty to rescue and more institutional duties to rescue. So I think there's a tendency within rescue law to sort of devolve everything down to the level of the individual, which is a very neoliberal move. And I think that the individual actions seem very salient, but actually institutional actions and state actions have a much broader scope and sphere of power to affect. And so for me, one of the greatest ironies is that is with sort of child abuse reporting, like, oh, you have a duty to report, but then the state doesn't have a duty to do anything, so they can just say like, yeah, thanks for your call, hang it up, and it's game over, and that's ridiculous.
Yeah, I see where we can go too far with a duty to rescue. I also see where we can go too far with a duty to report, as has occurred in some countries. Germany, at one point before, you had to report denounce your parents, a form of reporting. So yeah, I guess almost anything can be taken too far. Even reporting requirements, although they certainly haven't to date. There's certainly a lot of room to twist people's arms to reveal horrific things that are going on.
So I agree that there are that we should think of them both together and separately, the duties to rescue and the duty to report. A lot of people refer to the duty to report as sort of a subset of the duty to rescue. And, there are ways in which, of course, the two duties overlap, but there are also ways in which they're distinct. So, for example, given that the duty to rescue requires direct intervention, it's typically, I think, more perilous than the duty to report for those who comply, because the intervener's identity would be more likely to be revealed, and he or she may be ensnared in the very danger he or she seeks to mitigate. So there are, because of the logistics in the differences between reporting and rescue, I think there are differences that merit different treatment. It's important to note, though, that some duties to rescue are explicitly satisfied by reporting. So again, there's a lot of sort of sense that reporting is sort of a subset of rescue.
Great. More questions?
I don't, as of now, have any questions, any more questions from the audience, but I'm checking.
Okay. Any questions from panelists or comments from panelists? Well,
I'll chime in with one then. So we had discussed talking about the advantages and disadvantages of relying on criminal law to regulate rescue, as opposed to other levers like maybe tort law. Whether anybody wants to weigh in on whether we're in the right sphere or barking up the right tree or not.
Well, you know what? You raise a wonderful point. We had a very, I pointed out the German reporting law that was horrific, where kids were denouncing their parents and the parents are being taken away. But we've had the common law, and we still have federally misprision of felony, which is a broad duty to report any particular felonies to the government that you know of. And the common law lived that down because that was so very invasive. So we started out, at some point, we had an extremely broad duty to report, vast duty.
Yeah, I'd like to speak to kind of an oddity in the realm of migrant rescue. So, earlier Sarah had talked about like aiding and abetting liability, and I think in the realm of prohibited rescue, often a rationale that comes to mind is, well, you can't assist this person because they're doing something unlawful, or there's some kind of primary wrong that you can't participate in. And I think that breaks down when it comes to harboring, because with harboring liability, you're actually talking about someone who's already here. So they've already effectuated an entry. They might have come in on a visa and overstayed. So it's not even that they necessarily entered illegally. And that existence, without permission is a civil immigration violation. It's not a federal crime. And so the idea that there would be federal criminal liability because you're assisting someone in essentially committing a civil immigration violation, to me, doesn't make a lot of sense. And so I think that assumption that aiding and abetting liability kind of offers a rationale for these prohibitions is not a complete explanation or satisfactory.
We've got a few more questions in the chat, but I will just chime in on Shalini's point. Often in the fetal endangerment law context, women are being criminalized for their behavior during pregnancy when they would still be legally and constitutionally permitted to seek an abortion. So they are criminally prosecuted for behavior that poses a risk of harm to a fetus that they still have the constitutional right to abort should they choose to do so, which is nonsensical. Okay, I've got, all of a sudden I had a flurry of questions, so I'm going to take them in order. Shalini, is there anything in the old doctrine of the duty to rescue at sea that is helpful in the context of migrants crossing the desert attempting to enter the US?
Yes, so the duty to rescue at sea is fascinating, and it is absolutely an important area, I think, for scholars to continue to look to for analogies. Unfortunately, those duties have never kind of easily been imported to land. And so, and there have been scholars who have talked about why not. And I think some of it has to do with the sophistication required to rescue at sea. So if you are sort of in a ship and you see another ship in distress, it's not like some other bystander is going to sail by and take, and render assistance. It's kind of on you. And so I think the law of the sea sort of evolved to put that duty on ships at sea. But when it comes to land crossings, there isn't that same reasoning. The idea that that assistance would be so unlikely. And of course, we're assuming that it were not criminalized in the first place.
I think there are probably traditional cultural reasons as well. Where we in the pioneer westward expansion, people had to be self-reliant. This sort of cult of what they call rugged individualism, where if you were required to aid your neighbor, this would impede your ability to become self-reliant. So I think there's some old culture, which of course are outdated since Los Angeles is pretty full right now. But perhaps it jives too with the pure spirit of capitalism, where the selfish struggle of individuals works to the common good of all.
I think this next question is super interesting, and I don't immediately have my own answer prepared for it, so panelists, help me out. Any thoughts on how the duty to rescue or report might be extended to the police? This includes creating a positive right to rescue civilians and a positive right to report on fellow officers who, for example, use excessive force.
There is a growing movement to, my understanding is some states do already have those bystander laws for police officers. They're just not enforced very well. And so I think there is some momentum now to both enforce them and initiate them in a more widespread manner. But I don't have any insight into the first part of the question about whether they should have a broader duty to protect the public. I mean, I assume their mandate is pretty broad as it exists. It's just not happening.
I have a thought on this topic. In my forthcoming article, Digital Age Samaritans, I propose in the model duty to report an explicit exemption for individuals whose report would concern police brutality if those individuals are not themselves employed by a law enforcement agency. So the idea here, why I think that you shouldn't be required legally to report police misconduct is how inherently perilous that situation could be for people, given that police are armed. There's concerns about racism and racist violence by police. And so I wouldn't want Bad Samaritan laws to be used to further imperil civilians when facing police misconduct. But it's a great question about whether police should be required legally or through perhaps codes of conduct in police departments to report on each other. And that would, in many ways, that would actually make most sense because, in the case of, for example, George Floyd, there were 3 other police who were present while he was being killed. And those other police are best situated to intervene, if only by reporting what was happening, if not also by physically intervening as a sort of duty to rescue.
Just to beat my same horse to death. Again, though, you can see that's another situation where we look at the individuals who are right on the scene when really it's the department that they're enmeshed in that's going to set the norms of whether people are actually reporting on each other. And so I just think it's so important to really hold institutions and organizations to account for their role in these failures.
Yeah, lawyers are required to report corrupt or incompetent lawyers, and that doesn't happen. Strikes me that you'd have the same sort of dynamic here.
We know we have 2 more questions left in the chat. Should I?
Please do.
This is Jennifer Pusateri from GW Law. Is there the same kind of data on the effectiveness or lack thereof in the duty to protect scenarios Sarah discussed as in the fetal harm context? I'm wondering about the application of some of the arguments Megan made to maternal duty to prevent scenarios. Sarah should answer this, but my guess is that the data there is a lot harder because if there's data sets that are robust and accessible, it's like birth death data, whereas I imagine your data is messier.
Yeah, not to my knowledge. I think the only thing you'd be able to go by is just sort of general child abuse rates, which I'm not sure have changed significantly since. So it's also tough because there's so many different legal buckets that it can fall into. So 29 states have specific failure to protect statutes, but all states have general statutes that are going to be used in those scenarios, everything from accomplice liability to actual forms of homicide sometimes. So you'll get manslaughter charges against women for failure to protect and things like that. So yeah, it would, as Megan says, it would be much messier, but I'll keep looking to see what is out there.
I will say this isn't exactly the question that was posed, but as I mentioned in this sort of current project that I'm working on, one of the things that I'm looking at as another potential law where one might argue about sort of perverse outcomes and irrationality is criminal laws dealing with mandatory arrests in domestic violence contexts, because there's sort of a increasing body of knowledge and research that suggests that mandatory arrest laws in the domestic violence context often decrease reporting and increase lethality of domestic violence. So again, not exactly what the question was, but I think another area where my sort of framework might potentially apply. I mean, I hope it potentially applies because I'm writing a paper about it. Okay, so next we have.
Can I share one further thought on this topic?
Oh yes, I'm sorry. I didn't mean at all to rush us.
Sorry. On the topic of Bad Samaritan laws, sort of generally duties to rescue and report, it's really hard to determine empirically how effective they are, and I think there are really two reasons. One is that very few people know that these laws even exist. And then the second problem is that they are seldom enforced. And so the combination of these 2 issues, I think, lends to this idea that they just don't play much of a role in societal views and conduct on intervention. And so it's really hard to try to find data on the extent to which they matter, at least in the present day. Thanks.
I'll just add in, so that just triggers for me. There is one area where we have some empiric, and that's bystander intervention programs, which are these, they're mandatory at most college campuses now, where incoming freshmen have to take this course that teaches them how to intervene if they see potential sexual assault about to happen. And they do now have data on how effective those programs are. And interestingly, they find that they do help change beliefs in a statistically significant way, and they have a statistically significant impact on behavior in terms of intervention up to 6 months, at which point it becomes no longer statistically relevant, and they have no impact on actual perpetration. So just some interesting data to add into the world of empirics on bystanders.
I'd like to just finish up with two comments. First is, I just wanted to warn Zachary about it looks like there are giant insects right behind you. I think you're in danger.
Jellyfish.
Oh my, that's worse. And second, I don't know if it's an observation and a question for everyone. Maybe just to think on about. I wonder if taken together, the presentations we've heard paint a broader picture. 3 of the 4 talks have enlightened us on burdens the law has placed on women and those giving aid to migrants. And the 4th talk outlined an important protection that law accords to women. Although saving life has been the traditional aim of rescue law, the duty to come to the aid of others in an emergency is generally and callously absent from our law, from American law. Do the presentations we've heard from signal an adoption of a weaponized form of the duty to assist that blames and penalizes vulnerable groups? And finally, I want to thank everybody for participating. The panelists, our audience, it was a very enlightening and enjoyable panel for me, and I hope for you too.
Thank you so much.
Thank you.
Thank you.
And panelists, I popped our last question into our chat if people want to follow up.
Thank you, Megan. Thanks, Jay. Thanks, Shalini. And thanks, Sarah. This was great.